James William McCoulloch was dispatched to Baltimore to serve as the head of a newly established branch of the Second Bank of the United States, a prominent position. He, along with the United States government, didn't plan on the state of Maryland getting in the way via an attempted tax on banknotes. Refusing to pay the tax, he incurred the wrath of informer John James, sent to collect the fines, as James filed suit against the bank for failing to pay the taxes. However, neither the men or institutions involved could have predicted the crucial outcome of the case that was soon to be known as McCoulloch vs. Maryland.
William Althouse, this is 5 Day Minutes.
The Odyssey began in 1816 as the United States government incorporated the second edition of a national bank to be centered in Philadelphia, with a secondary branch soon to be established in 1817 in the city of Baltimore, Maryland. This branch of the Second Bank of the United States operated just like any other bank in existence, issuing banknotes and discounting promissory notes amongst other activities.
How you doing today, Mr. McCollum? So what was your role exactly at the bank, Mr. McCollum?
I was head of the Baltimore branch with the Second Bank of the United States of America. I was the man in charge of things.
So what was your response to the actions of the General Assembly in Maryland of 1818?
Frankly, William, I was stunned. I could not believe the audacity of these Maryland legislators.
Those Maryland legislators had in fact attempted to tax the Baltimore branch by passing an act designed to impose a tax on all banks or branches in the state of Maryland that had not been chartered by the state legislature. Behind the general premise, though, the act was more or less directed against the National Bank, as its Baltimore branch was the only institution to fall under the category of banks which would not have to pay the tax.
Honestly, the tax itself was just ridiculous. I had never heard of anything prior to it.
The taxes were taxed against all banknotes issued by the Baltimore branch, with the tax amount increasing as the note amount did the same.
We were talking different tax amounts for 7 different bill values here, from $5 all the way to $1,000. And to think they tried to offer us a yearly buyout clause for it. William, it just gets me so worked up.
And how much was the buyout cost to your branch?
$15,000 a year, William. And this is just to put a stamp on the tax notes.
In fact, the way in which the Maryland legislature created the act left open the chance the public could be subjected to its fines too, with a maximum fine of $100 on the table for anyone caught using the banknote from the National Bank without the desired stamp on it.
So I'm guessing there was no actual chance of you accepting and paying the tax to the Baltimore branch?
Absolutely none. Maryland had no authority to do what they tried to do.
This already feisty issue was then made all more chaotic by the arrival of informer John James. James, whose job was to collect the $500 fine McCollum and his branch was accused for refusing to pay the taxes, was further enticed to his duty by provision in the Maryland Legislature Act, which distribute half of the penalty money to the informer while the other half went to the state.
I was working as an informer at the time, doing what I had to do to make a living. That's all I have to say. I need to earn money as well, just like Mr. McCulloch.
So in an effort to earn those $250, you sued Mr. McCollum?
I did. He refused to pay the tax. He additionally refused to pay the fine. I was just trying to get my rightful slice of the money for my work in the matter.
That lawsuit was appealed to the Maryland Court of Appeals, where the state of Maryland stated its position that the Constitution is silent on the subject of banks. Maryland took a strict constructionist approach to the situation, claiming the Constitution did not specify the state that the federal government was authorized to charter a bank, rendering the Bank of the United States was unconstitutional and questioning even the existence of the National Bank. Quite the elevation from a simple dispute over fine collections. The state of Maryland believed that the United States had no grounds onto what they could justify the creation of the National Bank, seeing as that it was never expressly mentioned in the Constitution. Unsurprisingly, the Maryland Court of Appeals upheld the state's decision in the case. Although this was far from the end of things, the case was soon appealed all the way up to the Supreme Court, the highest in all the land.
My itself, along with the United States government, are not going to take this unconstitutional claim toward a national bank without fighting it all the way. We wanted the Supreme Court to decide what was legal once and for all.
Chief Justice John Marshall then took the mantle on the case and delivered what would become to be known as one of the most pivotal Supreme Court rulings of all time by stating that Congress did not have the power to create the bank, with several reasons to support his claim.
Firstly, we have established a historical practice of allowing Congress to create a national bank for the first Bank of the United States, which was chartered in 1791. This reinforces the idea that it is constitutional to create a national bank because it has already been utilized in American history. Secondly, just because a state, in this case Maryland, ratified the Constitution, it does not give them sovereign right. It is my interpretation that the people truly ratified the Constitution, not the states, and that is why the people are sovereign, again, not the states, and that is why Maryland's argument was refuted. Additionally, the Supreme Court and I rendered the decision that while the Constitution never specifically gives the United States government the right to create a national bank, it never takes away that right. This led to the invoking of the necessary and proper or elastic clause of the Constitution. This gives the national government the right to create anything within their given powers, so long as that it is pertinent to their given powers and to the betterment of the country as a whole.
Essentially, the Supreme Court decided Maryland's argument was null because of your review on proper clause?
Correct. In our view, the necessary and proper clause goes back to the procedure for implementing constitutionally established powers. All that can be construed within the scope of the Constitution, and that is not expressly prohibited by the Constitution, is, in our viewpoint, constitutional.
The official Supreme Court decision found that Maryland's attempted tax was in fact unconstitutional and that the Congress holds implied powers that only have to be related to the text of the Constitution.
This case represented a huge victory for the federal government as well as the national bank, as it limited the unconstitutional decisions of the states.
The Supreme Court case ruling was also used in a later global sense in the first major constitutional case of the High Court of Australia, with the same ruling reached by the High Court as was by the Supreme Court. Thus concludes our look at today's featured case of McCoulloch versus Maryland. For all of us here at 5 to 8 Minutes, I'm William Maltos. Good night.